let's see. Starting a couple minutes early. Let's see. All right, looks like we're good. We hit the buttons, we did the stuff. So we're starting just a minute early because I want to make sure everything's good. But let's see. Man, it's been an interesting couple weeks. Hopefully you guys have been well. We'll give it just a second. Yeah, after the storm, we've been without power for almost the last week. And so that means internet's been down too. It's been fascinating after the storm. So, all right, cool. We should be ready to go. All right, good to see you guys. Hope everybody's doing well. Hope you've had a fantastic last couple weeks. So we haven't had a lot of updates. I'll get on there and show you kind of what's been going on in the court case. We haven't had a lot going on the last 2 weeks. So just not many filings or things actually being added. So we didn't have a lot to talk to. My wife and I moved out to Houston, which has been a wild ride. And so we were here just in time for the hurricane, which was awesome to watch and be on the inside of. We didn't get a lot of it, but it was pretty crazy. And then we've been without power for about a week, so it's been a ton of fun. So let's hop into this court case and do some updates. And I'm sure we got a lot of stuff to go through, but I kind of want to show you a little bit of what's been going on in the court, just to kind of show you that I'm not making stuff up here. But let's go through and you can see exactly kind of what's been going on. So our last live, I think, was on like the 21st or something. So we were talking about these ones originally. We had talked about, really there's two complaints that have been going on. And so one of them is around the time frames for the discovery. And the Olsons want to continue to give discovery after the termination. And so we've talked a lot about that, and we'll kind of rehash some of those things. They're still arguing about it today. And then also how they've been filing things, what they call under seal, which means basically who gets to see these documents once they're submitted. So if you remember, they're doing discovery, but part of the challenge is these messages that are coming out are showing people who potentially are still maybe working with WFG or still there in some kind of capacity, or maybe their spouses, and they're having these conversations. And so filing this information under seal doesn't allow WFG to actually know about it. So there can be people who are still working inside of the company who are playing on both sides of the fence, and WFG is not allowed to know about it. And that creates a whole bunch of different issues between the lawyer and their client, because they can't have simple conversations about the information that they're receiving. So that's creating some issues, and they're continuing to talk about that today. And then these filings came through, basically just change of address, change in counsel. They had granted some of the motions from last week, which are just simple 1 or 2 pages saying yes, confirming kind of the stuff that we already knew. Then this came out on Friday, but actually they uploaded, it seems like, at the end of the day. So we got this last Saturday. As far as what we're going to start going through today, which is going to be the response and the motion to the judge, because WFG was saying, look, we've never made an actual date for discovery. So originally when they asked for discovery, there was no real date range to it. The judge said that they need to narrow it, so they narrowed it down to September. But now Olson's side is saying, well, we decided that it was from January 22nd after the termination. And so we're going to kind of be talking about some of those things. There's a couple exhibits that got dropped as well, which I thought were kind of cool. We're going to look at part of Shorack's testimony, and it's just going to be the last part. So I kind of dove into that a little bit. Apparently they went for like 4.5 hours. Poor guy. Could you imagine sitting there talking between 2 lawyers for over 4 hours, giving your video testimony, so it's being recorded and everything else. So we'll go through a little bit of that. And then we're going to talk about this, the discovery letter brief that WFG has. Also, Olson's side of it. And of course, they're doing yard work right now that we have power back. So sorry about that. Hopefully that's not too loud as it's coming through. But we'll talk about both Olson's side, WFG's side, and then what they went in front of the judge on Wednesday the 10th and what they actually talked about there. Then we'll also see in some of that both Eric and Sandra were supposed to have given their testimony on the 10th and the 11th, but they were kind of complaining about they haven't received some information, so we'll see if they actually did that or not. We don't have updates on that. And then these just came through this morning, and I haven't had a chance to go through them. So this will get us a chance to get caught up and kind of get back on track. So anyway, let's dive into the first one. And this is going to be the defendant's side of it. So this is going to be the Olsons. And basically what their opinion is on some of these things that they're asking about. Because they keep talking about, there's this weird thing that's happening around discovery and the time frames. And I can't really explain why it's happened, but it's been really interesting to watch from our perspective. Obviously, I'm not an attorney, I'm not a lawyer, I've just been in the financial industry for the last decade. So it's interesting to see a lot of these things kind of happen, and I've gotten a lot more into court cases with everything that's been happening with the former president, reading a lot of this stuff. And so it's weird the way this kind of got crossed up. And part of my questioning is, because the judge has a million other cases that are going on. He has his own life, he has his own other things going on. So I wonder how much of a priority a couple millionaires, right, a multi-hundred million, couple of 100 million, maybe $1 billion company arguing with a multi-millionaire. I don't know on the list of priority of things of importance how high that is compared to murderers and other people who do bad stuff. So I wonder if it just kind of gets lost in the shuffle, because originally what had happened in setting the time frames was, like I said, there wasn't one. WFG said we'll shrink it down to September to the termination or to the present, and then Olson's side came in and basically have only given things after January. And so this is kind of what they're arguing about, just as a little bit of a reminder. So basically they're going through and talking about this, and this is from Olson's side. So they're talking about the discovery history, and this case began with WFG filing a temporary restraining order, which we did not feel it would get. And so they put that in the exhibit, and I don't know why that really matters. So we're going to do a lot of flipping around today, so I apologize. I'm going to try to notify you as much as I can when we do it, and so that you can see that there's different documents. But part of what they put in with this was a statement that was made, and we're going to switch over to that. You can see these different exhibits that were attached. Do I have that one? And of course I don't have that one pulled up. Give me 2 seconds and we will do that. 196.1. Okay. Oh, it is there. I lied. Okay, group me text. Is it in here? Okay, so here we go. Hopefully you can see that. So, and it doesn't say who said this, but this was apparently some kind of message that was sent in WFG circles so everybody is aware it's being promoted. Actually, I think this was Rob Day that had said this one, but I could be wrong on that. So that everybody is aware it's being promoted on the GFI won the court case. And Eric Olson did that. He came out after the temporary restraining order was denied, and he basically said that they had won the entire case, which was not accurate at all. And so I think Day here is referring to that. And he's saying that the only thing that the courts have ruled on is the temporary restraining order, which we did not feel we would get anyways. And then it cuts off the rest of that statement, which we don't have. So they're basically referring to that, and it followed the discovery requests of the court found that were overly broad, compound, and not tethered to the claims or the defense in this case, which is true. So the original one just said, we would like to gather information, we want the documents, we need discovery, and so they didn't put a time frame on it. Once it got approved, the judge said, okay, I'll approve it if you put a time frame on it. WFG continued to use the discovery process oppressively. WFG refused to provide discovery, even as it's used a responsive document and not to produce in a deposition. The agents doctored the documents they have produced. I believe they're talking about Shorack here, which we'll talk about here in a little bit. We have part of his testimony that we'll go through. And they're basically saying that they changed the documents that they produce, which would have been valuable evidence, and they made them incomprehensible. And so we'll talk a little bit about that. We'll also go through exactly what they asked for, and you can see if Shorack delivered on his promise or not, and kind of make your own determination on that. WFG also raised disputes about confidentiality designations and many other issues to increase the burden to the expense of this case. So basically the claim that the Olsons and GFI are making here is that WFG is asking for these things purely to increase the burden and the expense of this case. And now when we go through Shorack's testimony, I want to ask you guys what you feel on who's really trying to increase the burden and the expense of this case. Because let me know how you feel about the lawyer is when he's kind of interrogating Shorack. We have a very small section of it. They went for about 4 hours, but you let me know what you think, and we'll kind of get into that in a minute. So each time the defendants addressed the issues, ran additional search term, added custodians, and simply moved on when WFG refused to honor its obligations. So they're basically saying that they've done everything that they're supposed to do and WFG hasn't done anything that they're supposed to do. And at this time, WFG has raised the same argument about the date range. It was first made in this argument on March 18th in a motion to compel, and judge denied it. Now, here's kind of what's interesting is it was put into a motion to compel. So a motion to compel is saying they weren't getting any of the discovery documents. So you remember, this goes all the way back to February. March was almost a month later. They were trying to get these documents, and they say, Judge, hey, can you tell them to give us these documents? We've agreed to all of these other things. We set a date range from September to the present. And then the judge denied the motion to compel. But he didn't deny the date range that was inside the motion to compel. So do you see how that gets a little bit tricky? It's kind of like my wife, right? We got to go to Costco today because now we have power and we got to restock the house with food, right? Now, if I said, hey, we should also get gas and stop at, I don't know, Trader Joe's on the way today. And she goes, oh, no, we don't need to go to Costco. And I say, okay, now does that mean that we don't need to go to Trader Joe's and get gas? No, she's saying that we're just not doing the trip to Costco, which was the main idea of we need to do some running around today, right? So that would be the idea of the motion to compel. We got to go do this. While we're doing that, we can do a couple of these other things. And she goes, no, we're not going to do Costco today. We'll do it tomorrow. So it's not saying no to the other things, which is kind of what the assumption is from GFI's side. They're saying, well, you got denied the motion to compel. They're not going to force us to produce discovery. So that means it's denying the date range, which to me, those are two entirely different things. They just happen to be in the same filing. So, but they're taking it as the judge is denying the date range when no, he actually denied the motion to compel. Two different things. It then sought relief from the judge, and this court denied it. So the relief that they were seeking was about the date range. And so the judge has kind of gotten this confused, and this kind of goes back to my original statement of asking, because the judge has so many other things going on, and the priority list of this, did he just kind of forget? And this is the, I don't know, the great part of if you're a lawyer and you could get away with some of these things, in that you tell them, well, you've already denied it in this other one, so why do we need to hear it about again if you denied it in the other case? And WFG is going, well, you never denied saying we need to go to Trader Joe's. You just said we're not going to go to Costco today. We were just going to do that in the same run. And so the assumption from GFI was, well, since they denied that, they must have also been denying the date range, which is absolutely absurd. It has nothing to do with it. And so that's kind of the assumption that Cousins has taken. He never went back and actually looked at the motion to compel, because in his denial, it was not about the date range. It was just saying we're not going to force GFI to give these documents. The two of you need to work it out. It's kind of like the parent stepping back and the two kids are fighting, right? And they go, well, you two need to figure this out. And that's basically what Cousins did. It had nothing to do with what was actually inside the motion to compel or to do with the date range. And so then him backing that up and says, well, I still stand by that denial, but the denial was about the motion to compel, not the date range. And so he's kind of just going off of his previous statement. And so what WFG is saying is, well, no, you denied something else. It just happened to be in the same group. We need to go back and look at this. WFG nonetheless raised this argument several more times before Cousins, because Cousins has never gone back to actually look at what he denied, and that the denial had nothing to do with the date range. In this most recent order, Judge Cousins pointed out that the court clearly already twice denied the defendant's date range arguments. He didn't deny the date range arguments. He denied two other things the temporary restraining order, and then the motion to compel. He denied those two things, which didn't have anything to do with the selected date range that both GFI and WFG were arguing about in their communications between each other. So that was never actually determined, which are inapt in any event. And so they're saying it has nothing to do with anything, because you got to remember the arguments here are that GFI hasn't done anything wrong, because if they're allowed to break all of these covenants, then they were fired, they were terminated without cause. WFG's side is saying, well, you broke our contract, so then therefore you were fired for cause. So GFI's argument, if we were not fired for a cause, then nothing matters leading up to it. It only matters what happens after. WFG saying you were fired for cause means that they need to show what had happened leading up to the termination. And so that's all got kind of convoluted in all of this, that everybody's kind of overlooking. They're not seeing what the actual argument is. They're arguing about little details that are outside of the entire scope. And so they're coming from two different, I guess the easiest way to say it is they've got two different colored glasses on. And so they're looking at it from two different perspectives, and the judge hasn't really seemed to come through and actually explain that. So sorry, I know that was long, but trying to get into like why there's a dispute here still and why it hasn't been broken up, and where the judge's oversight perhaps might be, or maybe his level of priority isn't that high on this particular case, that he's just kind of say the GFI has done a great job in saying, well, is kind of the husband going, well, wife, you've already said no to these things 2 times, so we don't need to talk about this again because you've already said no twice. And even though it had nothing to do with the actual conversation here. So he further explained that that's my ruling, and part of it is informed by the discovery, which I've now in quite a bit of record with filings and hearings before me, that I don't see the fairness grant in basis to grant you more discovery. So here's the messed up assumption, is it's not more discovery. The assumption that GFI has done a great job in wording was, we agreed on January, and now WFG is coming in and asking for more discovery, and that's not true at all. From the very beginning, WFG has asked, and they reduced it to starting after September. So it's not more discovery, it's the original discovery. So again, GFI has done a great job in coloring the lenses of the judge to see it from their perspective, which I think is inaccurate. If anything, it's going the other direction. And so since the discovery is coming out after January, so think about January 22nd as the date of the bank robbery, or it's actually a couple days after the bank robbery, and I'm not saying the Olsons robbed a bank or anything like that. I'm not saying that. It's just an analogy. So they've got 2 or 3, 4 days after that when Eric Olson actually gets terminated. Well, all of the colluding happened beforehand. And so now the judge is saying, well, we might actually need to go the other direction because you're not getting the information that you thought you were going to get, and it's all based on this discovery date range because they're not getting all of the information leading up to the termination. They've only got it afterwards, which doesn't really pertain to a lot, but even in that, they're finding information that is to their benefit. WFG is finding information to their benefit, that there are people that were working inside of WFG giving information to GFI, and that's why the second argument is then going to be over, well, who gets to actually see these documents? So the reason for the ruling date back to February, when the court allowed WFG to take the expedited discovery in the light of the upcoming conference in Hawaii. In response, the court orders defendants immediately image their devices. So what's even more messed up, or the question that I would have, is, well, why did you image your devices from the September date range and then only give us from January? So if you were never planning, if the date agreed on was January, why did you collect the information from September to January? Well, because that was the assumption. They just never turned any of it over. And now they've coded the judge's lenses to see their perspective on it. So it's not that WFG is expanding it, it's just that they never actually got what they asked for. So answered broad written discovery within 5 days of WFG demand and ran 25 comprehensive service searches across everything they've collected, including WFG. The goal was to immediately capture and produce every communication to or about WFG and its workers since Mr. Olson's termination. See, here's the assumption again. Here's the coloring of the classes. The since Mr. Olson's termination. No, they need the information leading up to why he was terminated. WFG discovery on its claims of the defendant's alleged violations of WFG non-disparagement, non-solicitation, and confidentiality language was causing WFG's irreparable harm. So that was happening prior to the termination, not after. Do you see how they're using this language to color the judge's lenses to look at it? Well, you've got everything after the termination, so why would you need more discovery? Well, because that has nothing to do with what they're actually looking for. So the date range was necessary because WFG's request had no temporal limit, which is true. In the beginning, they had no limit. They just said, hey, this is the information we want. And then they came together with GFI and limited it to September. And it would have been impossible to accurately answer all of the written requests within 5 days, running 25 expansive terms, WFG, every email footer, and every email predating Mr. Olson leaving. WFG had moved to compel arbitration and was refused to provide merits on discovery, which is extra pre-termination discovery. So see how they're making it into two different topics. They're saying, well, that's pre-termination discovery. And so WFG imposed the same date range limit on its own production. Well, here's again the coloring of the lens. Because the information that Olson was asking for was about the temporary restraining order. There was no information about the temporary restraining order until after Eric's termination. So there would be no information about the temporary restraining order before Eric was terminated. That would make no sense. There was no lawsuit. So they're doing a great job at making it look like they're in the right, and I think that they are not. So this court has held that there is no injunctive relief that could craft the basis of the defendant's conduct while he worked for the plaintiff. Again, because they're saying he did nothing wrong and he was terminated without cause. So there's nothing to look at because he didn't do anything wrong. And this is where that whole debate around the not non-solicitation, the non-compete comes into place, which also hasn't been determined yet. Okay, so then let's talk about the attorney-only documents. So they have that whole issue where they're not getting the information from September to the termination. But after the termination, they are getting documents that are showing that there are people in GFI who are also still working in WFG or are giving some kind of information to GFI from WFG. Okay, and so now the second layer of defense that GFI has is, well, now we're going to label all of those documents that come out, all of these text messages. So Eric Olson, I'm just assuming I'm making this up, text messages, somebody who's working in WFG, maybe this was the other guy, Maboni, that they caught, right, trying to recruit WFG agents at WFG events. And so he's text messaging somebody like Maboni and says, hey, how's it going? What's going on in that event? How many people did you recruit? I need you to focus on this guy. He pulls up the report and says, hey, this guy's doing really well. Make sure you grab him at that next event. Make sure you talk to this guy. Make sure you talk to that guy. Well, now WFG is not allowed to see those because it goes into attorney-only documents. So they're getting very limited discovery, not anything that they asked for. The discovery that they do get, now GFI is hiding it in the attorney-only document. So let's say that there is somebody still working with WFG and GFI is in direct communication with them about events that are coming up and people they want to recruit and that kind of stuff. Well, now when that gets captured and given to the attorneys, WFG doesn't get to see it. So they're not allowed to go in and actually stop these people from doing what it is that they're doing. So they can be non-soliciting, or they can be soliciting WFG agent, they could be giving disparaging information, they could be using confidential documents. They can do all of that stuff and WFG wouldn't know about it, but their attorney would, which starts to create a divide between the attorney and their client because they can't talk about simple things that are happening inside of the case. So GFI's lawyer, their group, they're doing a great job on concealing all of the stuff that it is that they're doing, and continue to do, apparently, because they're still fighting about it in the documents. So the attorneys are trying to turn for WFG, are trying to make some of these documents available so that they can tell WFG about it. So imagine there's a raid that's happening right now with somebody who's still in WFG. WFG isn't allowed to know about it, so it just continues to happen. And so they're basically saying that it's incorrect to make these documents available to WFG because it would create a substantial risk of harm to those particular agents who are still working in between or are working simultaneously at both. So they don't want these documents turned over to WFG because it would, quote unquote, create a substantial risk of serious harm, right? Because they would get terminated for breaking their contract. But this protective order is the next cloak that they're using, that this doesn't get turned over to WFG, and so they can't do anything about it. So under the protective order, for many reasons, including WFG expressively stating that it intended to use information produced in this case, including those two documents, to retaliate against its workers. Well, yeah, if you have, I don't know what other word to use here, but a spy inside of the company who's giving information back to GFI, of course, it's not retaliation at that point. They have broken their contract, and then they would need to be terminated. So they are not, WFG then is not allowed to know who these people are because it protects them from being retaliated against when they're the ones that are actually doing the thing. So it would be like you have an employee, imagine you run a business, you have an employee who's stealing from you, but you're not allowed to know, only your attorney is allowed to know, and they're not allowed to tell you about it. So you just have to keep going about your day while people are stealing from you behind the scenes and pretending they're smiling to your face and going to events and pretending to care about everybody, while behind the scenes they're taking clients and agents and everything else, and WFG isn't allowed to do anything about it. So courts regularly hold the fear of unlawful retaliation can serve as a basis for marking documents highly confidential under protective orders. So where this is kind of supposed to come into place would be a whistleblower. So we have a lot of that going on in the government right now. And so where this is supposed to protect them is that they don't go and get fired because they're reporting about things that are happening. What it's not supposed to do is protect co-conspirators from doing what it is that they're doing. And again, this isn't a job. It's interesting how when GFI makes these comments, they're independent contractors, and so that way they should be treated individually and independently outside of the business. But when it comes to these types of things from WFG, well, now they're basically employees of the company, and so them being fired or them being terminated would then which would be considered to them retaliation. So WFG keeping its contract is considered retaliation to them. So kind of interesting the way that they're putting that into that. So anyway, they're talking about more case law here. The protective order here specifically allows the use of highly confidential designations where disclosure would create substantial risk of serious harm and could not be avoided by less restrictive means. And so, as with any claim between two competitors, attorney-only designations will not interfere with WFG lawyers' prosecuting its claims. WFG presented no evidence of any prejudice of Cousins. I don't think it's prejudice from Cousins. It's just a misunderstanding. I don't think Cousins is going off of an inaccurate assumption. The inaccurate assumption was that he already denied the date range when he didn't. He was denying other things that happen to have the date range in it. And it explained that it wants to use these two documents to retaliate against its workers. It's not retaliation. They have broken their contract. They are doing things that they're not supposed to be doing, and therefore they should be terminated. They should be terminated for it. It's like saying we have evidence that your cashier is taking money out of the cashier. However, you would be retaliating against them if we showed you the video evidence that they're actually taking money out of the cash register. That's not retaliation. They're getting fired for not doing their job. Very, very different. So, all right, let's get into, let's see, what was the other documents? I don't think they related to those. Okay, so let's get into the Shorack videotape deposition. And I want your guys' opinion on this. I read it through quickly, just kind of an idea of how it works. It's put in here very weirdly, at least in my opinion. I don't know if that's a word, but it is now. So they didn't give us the whole thing. They just gave us part of it. And it's numbered weird. So I'm going to bounce around on this page because it's 4 documents and it goes 1, 2, 3, and 4. You would think it would go maybe this way or something else, so we're going to kind of bounce around on these pages, but basically they're taking his deposition. This is back from May 15th, so it's not necessarily new information, it's just new to us because we haven't had it. And so he's introducing himself, he's basically spelling his name and going through, and basically they're getting introduced. And that's on page 5. They go for about 3.5 or 4 hours later, and then it picks up where we actually get the information. And so you tell me if you think the attorney is being fair on this, or if you think he's just, I don't know how else to word it other than saying he's basically punishing Shorack for his dissent from Eric Olson. And part of it seems, at least to me, like they are just hounding him because he's coming out against Olson. And so they're trying to make it as inconvenient for him as possible, right? You can't necessarily do anything directly, but you can make their life as uncomfortable as humanly possible. So we're going to kind of get into this. And so there's the lawyer who's going to be asking questions. So anytime you see Miss Jameson, I believe that's how you pronounce it, that's going to be their attorney. Anytime you see witness, this is going to be Shorack, obviously. And then Mr. Altura is going to be Shorack's attorney. So he's going to be interrupting any time that the Olson's attorney kind of gets out of line. And he has to do a little bit of it. So this is going to be the GFI's attorney, Miss Jameson. She says, do you remember why he asked to talk to Mr. Bosley? So remember, we're 3.5, 4 hours into this deposition already. And Shorack is saying, I don't really remember, but everybody in the company wants to talk to Nick Bosley. I haven't met either of these guys, but apparently they're pretty famous at the company. So, but he's saying everybody wants to talk to Nick Bosley, so it's not unusual. Well, the attorney asks, well, why would they want to talk to Mr. Bosley? And the judge or the attorney for Shorack steps in and says, calls for speculation. And Shorack here, he still answers the question anyway, which is kind of interesting. You're not really supposed to do that. But I think to me, he just seems like a genuine guy who's just trying to be honest and do his best. And he's kind of stuck between 2 attorneys who are going back and forth at each other. So anyways, he says, I don't know. I can tell you why I want to talk to Nick Bosley, but I don't know. I can't speak for anybody else. The attorney asks, is Mr. Bosley senior in the company? Nick says, yes. He's a senior vice executive chairman with the company as far as I know. Question, the attorney asks, is he at the same level as you or higher than you? Nick says, he's a higher level than I am. The attorney asks, and was he in Mr. Olson's hierarchy? And Nick says he was. And so you said that everyone wants to talk to Mr. Bosley. Is that related to Mr. Olson's termination or GFI? Nick's attorney steps in and says, same objection, lacks foundation, calls for speculation. So the reason why Nick shouldn't answer this is because he has no idea what other people's ulterior motives are, right? So he can't speculate on that. And so for him to say what somebody else was thinking is just not really possible for him to do. So the attorney basically is saying, hey, you don't need to answer this question. And he says, my speculation would be no. So they talked to he's saying that they talked to Bosley for all different types of reasons. He's just guessing, but it could be other things other than Mr. Olson and GFI. So the attorney asks, I'm going to introduce other documents that were produced this morning. This is Exhibit 12, and we don't have that, or I'd share it with you. Share my screen with you in just a second. This is what was produced to us. The title is Nathan Shorack Text Messages. Witness says okay. Jameson says, are these screen grabs from your phone? haven't been marking today. Hold on. Are these screen grabs from your phone? He says yes. Oh, he says, I don't know. Hold on a second. Can you make that a little bit bigger? It looks like it. Yeah, if we provided it, it came from my phone. Is there a reason that these screen grabs were produced in a single document? They appear to be text messages of different people. So it sounds like they put everything into a single file, maybe to make it easier for them or whatever it might be. And she's questioning about that, like why weren't all these separate different documents? And the attorney steps in and says that is correct, and I will represent to you, Molly, that Mr. Shorack provided his counsel with screenshots as we discussed he would, and we compiled them into a single document to make it easier, I thought, on everyone. So yes, they are separate screenshots from Mr. Shorack's phone, but compiled into one document. The attorney asks, Mr. Shorack, who is Amy? He responds, Amy is the wife of a senior marketing director that's on my team. She asks, and so when she writes, Angel is an SMD here, RJ was an associate, I believe. RJ likely got brought into WFG as an EMD, which is their equivalent to SMD. Who is she referring to? That's me, actually. Oh, my cursor's getting weird, sorry. Which is interesting, too, because I had never really thought about this. If he's an associate, and they're willing to bring him in as an EMD, which is a very high qualification, why are they willing to do that? So they're giving away contracts? It's kind of interesting as well. I'll have to look more into that. So anyway, he replies, that's me actually. And so, yeah, she asked me a question verbally. This was my response. So you asked for any communications that I had, and so that was the communication that I had given. And she asked, and was there any reason for her, any response from her? And he says, nope, not that I can recall. And so the question they ask is, you had no further communications after this message concerning this message? And he replied, I don't think so, I don't recall. She asked, what did she ask you, what had she asked you, like what did she ask you for? She was asking, I think she was asking about what the contract level you would go over to GFI and if you were an SMD here. I think that's was the question was about, but honestly, I don't remember. She says, and it's not in the text message? He says, no. She asked me verbally. So then the next one is Carolina Santos. And again, that's your texting her. That's me texting Carolina Santos. And you asked her, did you guys decide to go to GFI or are you still with WFG? He says, correct. So Carolina Santos is in your downline? He says, no. Is she an agent with WFG? He says, I don't know. She never responded. There was no response to this? He says, no. What about Tara? So she was asking because there was some hecklers on a meeting we had that were saying negative things about Rob Day, and so she was asking what it was about, and so that was just me responding. Did she send a text message that you're responding to? He says, I don't recall. Counsel, can you represent whether text messages were redacted or deleted from the screenshots? The attorney steps in for Shorack and says, yes, they were. Your documents request asked for statements made by the witness. That's what we produced, exactly what you requested. So their attorney, GFI's attorney, says, so you deleted all context around those statements. Is that what you're telling me? And the attorney for Shorack says, that's what the request was for. I asked Nathan to provide me with the statements that he had made, and that's what we produced. The attorney for GFI says, so to be clear, Shorack, did you do the redactions and or deletions of the messages? Shorack's counsel steps in and says, excuse me, there was no deletion of messages, so I'm not sure what your basis is for making that statement, counsel. The GFI attorney says, I'm trying to understand what I'm looking at a blank context. And I think we go down here, yeah. He says, I just explained to you, maybe you should, did you note your redactions on the document marking them as redacted? Shorack's attorney says, maybe you're getting testimony on it right now. Maybe you should review your document request, counsel. That's what you asked for. We produced exactly what you were asking for. GFI's counsel says, well, we'll need to discuss this offline. This is clearly not what the request is intended to cover, and the idea that you're modifying documents to limit and make things unintelligible is clearly not what we were requesting. Shorack's attorney says, let's do it on the record. So he wants that to come out while they're doing this on the record. And she says, let's not do it on the record, which I think is kind of funny. I mean, she wants to argue about it offline where it's not being recorded. We have 4 hours into this witness. Poor guy. Shorack's been here for 4 hours already. I'm not using it to argue with you about what clearly is misrepresentation of this request. So we will discuss this offline, and I will reserve my rights. You don't, and Shorack's attorney says, you don't just get to say that without me responding to it. She says, you're welcome to respond and continue as I scroll through this document. Nathan's attorney says, I disagree with your characterization. We produced precisely what your document requested for. Statements made by Shorack. That's what you have. She says, I already made my statement on the record. Let's move on. She says, Mr. Shorack, one of these messages is to a group chat called Next Gen Leaders. Do you know who the members of that group are? And he says, I do. She says, and so counsel will ask you to provide the list of the following in the deposition of who those people are. And the attorney says, excuse me? She says, same here with these two people who are not identified in this message. Shorack says, okay. The attorney says, and again, she cuts him off. Who is Pedro? Mr. Shorack, who is Pedro? Pedro is a senior marketing director with WFG. Uh-huh. Is he in your upline or downline? Shorack says, I believe he is in my downline under Alex's leadership, Alex Navarro. She says, and so you send a text that says, incredible, GFI will work. It will just take a long time. He's young. It will work out for him. What are you referring to? Nathan says, probably Michael, I don't know. She says, that's because you can't tell from the text message as produced. The attorney for Shorack steps in says, objection, that's argumentative. She says, you can answer. And he says, that's because I'm just looking at the statement. She says, who is Rob? That's Rob Day. Rob Day, did you have another communication with Rob Day about GFI and Eric Olson and Sandra Olson? Not much. I mean, like I said, we did search for Eric Olson, Sandra Olson, and GFI, and that's what he had produced. And you produced your text messages with Rob Day, and this is the only message that you believe is responsive. He says yes. Did he send you text messages? He says, I don't recall, but I would be happy to do a search for you guys. Just subpoena me. And she says, we did. And he says, no, you didn't. She says, we are the, and then something, they're starting to argue now. So he says, I think this is irrelevant. You didn't ask me for that. You asked me for the statements that I made. She says, Nathan, please his counsel says, let me ask her the questions. Shorack says she's not being honest. And the attorney says, the record reflects everything that we've spoken about. So this text message here entitled three people. Who are these three people? Rob Day, I'm going to guess Altura, I think that's the attorney, and I don't know who MH is, but it's definitely Rob Day and the attorney. Oh boy. That probably shouldn't be in there. So he's giving more stuff that he probably should have, and so now the attorney is trying to claw that back. I'm going to have to claw that one back. She says, yeah, interesting. When you don't provide me metadata, you don't know what we're looking at. The witness says, I'm happy to provide you metadata, just use the program. And so Shorack had offered to give everything in the program if the Olsons and his counsel were willing to pay for it, because I guess it's fairly expensive to be able to do. And so the Olsons denied that, so they didn't use the metadata. Nathan went in there and just voluntarily gave up all this information. So his attorney says, I'm going to ignore your comment. We never had an agreement to produce metadata. These are non-party witnesses, counsel. You served extremely broad, burdensome documents demands. So we produced what you asked for. You didn't make comments like that and not expect a response, counsel. So I will say on the record, and she kind of cuts him off. She says, I will allow you to put it on the record, And the attorney says, I'd like that page destroyed, okay? And she says, I understand if you're asserting privilege over that document, follow up by an email and formalize that. She says, who is Dawn? Shorack says she's an agent with WFG. Yes, I wrote on February 26th, I'm not sure why these guys are leaving, but from my perspective, it's better than ever. But David has always marched to his own beat and basically followed Eric Olson. Something about him wanting to become a billionaire. So who are you referring to, these guys? Nathan says the people who are going to GFI. Are you referring generally to all people going to GFI? His attorney steps in again and says, counsel, I'm going to object to the question as overbroad and also note that I believe you're out of time. She says, could you let us know what the time is on the record? And so they're going to kind of go back and forth a little bit for her, and she's going to dismiss it. But I want to go into the actual document of what they requested, okay? And you can tell me if he's being fair or not in what he's delivering. And so they asked for, and I think maybe this is the challenge of what we're talking about here, all statements that you made to any former WFG agents, employees, or executive regarding Eric and Sandra Olson, statements you made regarding GFI, statements you made on or after the 22nd about WFG, serving, litigation, that kind of stuff, all documents related to any statement you made in your declaration concerning the above caption. So in that deposition or that testimony that he's giving, it sounds like he turned over all the documents that he made. And now she's mad that they don't have the responses of what the other people said. So it doesn't say to turn over all communications that revolve around this, which would have included what other people had responded to. It's just your statements that you made to particular types of people about certain types of things. So of course it's going to be out of context because it's a statement that he made. So I'm imagining how this would kind of go in a conversation simply that, I've had via text messages. And so you're talking about one thing and then you get into other stuff. It's a simple comment that he made about these things, which is what he turned over, but the rest of that communication before and after shouldn't necessarily be in there. So of course it's going to be out of context. So that's kind of what they're mad about here. But to me, it looks like he turned over the statements that he made. And so this is where I think the counsel, the attorney for GFI is getting a little bit out of whack in that they got exactly what they asked for. And so it's not necessarily Shorack or his attorney's fault for not giving the other information. But now the GFI attorney is saying, well, you modified all of these documents because you didn't give us the rest of what was going on. We have just the statement. We don't have the context before and we don't have the context after. So you went in and modified these things. You deleted the context of it in order to somehow disguise what was actually happening. So they're saying that his intent was to do something that he wasn't supposed to do. And what he's saying is, I turned over exactly what you guys asked for. I turned over my statements. You didn't ask for the statements or the responses from the other people. You asked for what I said, and that's exactly what he's turned over. So your guys' thoughts on that, let me know what you think. But they basically go through here, and they're talking about the time. They've been about 4 hours. His attorney's saying we need to wrap up, and she's kind of going back and forth. He says, are you answering the last, let's see this last question, sorry. How much more time do we have? Where was the last question? I missed it. Oh, could you let us know what the time is on the record? Nope. Oh, I guess she's referring to this question. Who are you referring to as far as these guys? And he said all the people who went over to GFI. She said, okay, counsel, are you instructing the witness not to answer that last question? He says, I'm not, but I would just like to see this wrap up. The witness says, how much time do we have? Can we wrap this up? We've been here 4.5 hours now. Can we go? Nathan, can I do the talking, please? He says, sure. She says, okay, thank you. Are you answering the last question? What was the last question? We were referring to generally everyone who was leaving for GFI or anyone specific. He says, I don't remember. She says, okay, counsel, you've gotten your answer. How much time do we have left? And then they basically dismiss him. Well, unfortunately, she makes him leave for 5 minutes. They leave for 5 minutes. They come back, and then she basically lets them go, and so they cut it off. And so it was about 4 hours deposition that they have. So it looks like to me he turned over what they asked for, so I don't know exactly what they're mad about, except for maybe they made a poor request on what they were actually asking for. So that's kind of where we're at with Shorack. I thought she was a little bit out of line, but who knows? I don't know. I thought she was a little bit overbroad. Maybe it was just the way that I read it. So we've got two more documents that we're going to kind of run through. One of them is going to be WFG's side of what they feel and what they're asking for and why they're going back over discovery dispute and that letter. And then we'll go through what they sat in front of the judge on the 10th about, and kind of the discussion that they probably had around those two different documents. And then I think we're done for the day. Oh, and then they were granted some stuff, but it's just some documents around that they wanted attorney's eyes only on. Okay, so let's go back into this one. All right, so this is WFG's letter to Cousins, and so Cousins is the attorney, obviously, that's on this. And so they're because if you remember, there's still this whole there's this dispute about the discovery letter and the order to compel. And so they're saying that that was submitted to produce communications which would not be shielded by the marital communication privilege. So the next layer that GFI is putting in place, so we have the messed up date range, only after the termination. Then we have the attorney's eyes only documents. And now the next one is going to be communication between spouses. And so if you know anything about that, you can't necessarily get in trouble for communications that you have with your spouse, unless it's to further a crime that you're committing, right? So that communication is also considered privileged. So now the next thing that the Olsons are kind of saying is the communication that they've had between each other, they don't want any of that to get into the court documents as well. So they're hiding that. It's basically saying it's marital communications. Now, marital communications kind of gets into this weird gray area because they're business owners. And so my wife and I talk about things about the business that are not necessarily considered marital communications because we work on things in the business together. And so those necessarily wouldn't have privilege to them because they're not pertaining to our particular relationship. They're pertaining to us working together on the business, right? So they're kind of arguing some of these things. And so WFG requests the court conduct an in-camera review of these documents, and at the time consider WFG's request in order to compel production of the communications. WFG first raised concerns regarding the Olsons of the marital communications during the privileged parties meeting and confer on May 9th. And the reason why I kind of want to go through this is so you can see a lot of what's happening. I think there's a lot of delay tactics that are happening in here. And so WFG followed up by written correspondence requesting further conference on June 7th, then on the 10th and the 12th. The Olsons responded with a letter on the 18th. So almost 2 weeks after they were supposed to get together and do the meet and confer, now they respond with a letter, but refused to meet and confer telephonically until WFG responded to their letter. WFG again requested to meet and confer on the 26th. So these have been happening the entire time where they're supposed to get together and talk about things, then it just gets put off longer and longer. So from February, this is 4 or 5 months now that this has been going on, and provided an amendment privilege log, supplemental document production, excuse me, and response to the Olsons letter on June 28th. Receiving no response, WFG prepared a joint letter motion, which we'll read here in a second, which they shared with the Olsons on July 5th. But the Olsons refused to contribute to the letter motion and to confer on July 9th. The parties remain at an impasse on this issue, and WFG submits this letter ahead of July 10th discovery hearing to ensure that dispute may be resolved without further delay. So if you remember in that other document we just read, GFI was saying that WFG is the one that's trying to draw this out, make it expensive, make it difficult on everybody by changing the date ranges on the information that they want and to kind of push these things off, and that they supposedly agreed on a date range and now they want more information. But to me, it looks like they were supposed to do a conference on the 7th. It's now past the 26th. We're now getting into the 10th, and there's been no meet and confer meeting to go over any of these things. So the question then is, okay, who's really delaying here then? And they're saying So this limited purpose is not implicated in discussion between spouses about their joint business dealings. So they're saying that there's a difference between just marital communications between spouses and then stuff that they're talking about that's outside of that. And so they're saying in this particular court case to cloak business-related communication between spouses with privilege when the transactions come to litigation would be productive of special inconveniences and injustice. Of the documents are not even identified as communications, but as images in confidential marital communications. Although this is the first opportunity that this court in the Ninth Circuit has to address that, the court in federal basically is saying that this particular court has not had any cases about this, so it's kind of new ground a little bit for them. And federal court cases have declined to apply marital communication privilege to business communications for this very reason. So imagine what's happening with the anchor leg strategy. And so one person's at GFI and one's with WFG. They're having communications about it. Well, all of a sudden, those just don't become protected communications if you're doing something in the furtherance, especially if it's to commit a crime or whatever, or break a contract or whatever it might be. So there's another cloak that's kind of happening. They're kind of saying, well, it's between spouses, so we shouldn't have to give up any of that communication, or it should be attorney's eyes only. So they're arguing about that. Moreover, the marital communication privilege should not be available where the interspousal communications are designated to perpetuate fraud on third parties. So just because they're spouses doesn't mean you get to hide all of that communication. So finally, even if the marital communication privilege applies, the Olsons have waived privilege and protection by putting their collaborative business dealings at issue. So they're asking for relief on that. Selectively disclose the details of their business collaborations, which require spouse participation, and put their business partnership at issue. Having used their relationship as a sword to employ the anchor leg strategy, and that's exactly what they're talking about, the Olsons should not be permitted to now use limited marital privilege as a shield to conceal evidence that would support WFG's preliminary injunction request. So imagine, again, we're going to take this completely out of context and say there's a husband and wife that go in and rob the bank. Well, they're conspiring the whole time about doing that, about committing that action, right? And so just because they're spouses doesn't mean that nobody ever gets to go in and judge those communications that they're having. So they might have communications about what they're going to do, how they're going to do it, who they're going to target, all of those kinds of things. And so that doesn't just get excluded just because they're spouses. But it's been something that they've been able to shield a lot of that because of, and this anchor leg strategy, I have to give Olson credit, is he found the loophole for sure in being able to do the things that he wants to do. And so anyway, the WFG requests that the court compel the production of responsive communication between the Olsons and other GFI custodians and their respective spouses. So basically, all of the people who were committing the anchor leg strategy are hiding behind this ability that they don't have to give up communication between the spouses. So Olson found an incredible way to be able to break his contract. I don't want to say necessarily commit fraud, but he's found a way to get around all of these things because it's literally protected in so many different ways. And so they're allowed to do whatever it is that they want to do. And so they're asking them to basically do conduct these interviews or these reviews on camera about any of the documents withheld as marital privilege and communication. So they need to determine, is this actually communications between spouses, or were they doing it in furtherance of committing a fraud? So they're basically asking for that. Now, what they went in front of the judge for on the 10th is going to be this document. So this is going to be both of their sides kind of rolled into one. I love these because it makes it super easy to go through, and we'll run through this pretty quick because you probably have the gist of it by now, but this is them breaking it down into smaller portions. So the applicable date range. WFG has raised the issue of the applicable date range before in this motion for relief in this particular docket 186. If you want to go back and read that, it is on locals. All of these documents that we use you can find over there. WFG's request for production of documents from September 1st to the present is pending before the judge and does not require further discussion on July 10th. So this is part of the challenge that's happened, is there's a lot of things that are sitting in front of this judge that just have not been ruled on that will make or break this case really for either side. Part of that is going to be the non-compete clause. What is a non-solicitation the same as a non-compete? Because if it is, then why are we doing all of that stuff? And these things are just kind of sitting in front of the judge and they haven't been determined on. He was also the one who has the information about the date ranges that are still pending in front of him, but that haven't been completed. So confidentiality designations, WFG requested that the de-designation of two key documents. And so these are probably of people maybe that are still conspiring or have conspired, but WFG hasn't been able to do anything about it, which the court has denied. WFG also raised this issue before the judge and its motion for relief at docket 186 also, which remains pending. Meanwhile, the Olsons down designation of 729 of their initial 978 documents and moved to remain the confidentiality of the remaining 249 documents. So this is such a great play. It's kind of like, I don't know, if you've ever been in sales, you kind of do this too, right? And so they ask what the price is and you joke and you go, it's $1 million, right? And so you give a big number and then you bring it down to the small number and maybe it's $10,000 and then they go, oh, okay, that doesn't seem as bad, right? And so the Olsons are kind of playing that same trick where they designate everything as classified. And I think 90% of these, I think all of these were screenshots. It might be these ones, might be different ones, but they were screenshots of the WFG website. And so they also filled these documents with just useless crap. They make them attorney-only documents. And then the other side has to come back and fight them to get them de-designated. And so then they go, okay, well, we'll give you 729 of these screenshots that we have of the website that really don't mean anything, but we would like to keep 249 of those as attorney-only documents, right? And they're playing the game extremely well, very, very well. I hate these games, but I got to admit that they're playing them well. So they look like they're giving up ground, right? So we turned over almost 1,000 documents, and we were willing to de-designate 70%, 72% of those. And so we're just trying to keep a couple of them classified when maybe none of them should be classified. And so WFG is saying that the designation of those 249 documents shouldn't be attorney's eyes only. And so WFG maintains that all these documents still do not meet the definition of attorney eye only under the protective order, and that the balance of harm weighs in WFG's favor. Failure to de-designate causes irreparable harm to WFG by preventing WFG from working with its attorney to analyze or address the defendant's scheme. Absolutely, it's able to still happen because they are not allowed to know who's behind any of these things. So hidden behind the improper attorney-only designation, even if the court determines that some of these documents may remain under attorney-eye only, the documents in the set fall outside of the scope of permissible use of attorney-eye only designation should be downgraded. So maybe 230 of those shouldn't be designated as attorney-eye only, but we need to go through and actually figure out which ones should be and which ones should not be, and they need to be downgraded. But great play by GFI to make them all and then act like you're giving up some ground. Party depositions. WFG will be taking depositions of Sandra and Eric. Sandra on the 10th. Eric's going to be on the 11th. Defendants Dewan and Carter have refused to participate in expedited discovery at this point. As such, fact discovery remains ongoing, which is interesting, right? Because they were able to say that Dewan and Eric, since they're independent contractors, even though they've been part of this whole scheme from the beginning, don't have to take any part in the expedited discovery simply because they're independent contractors and they have no control over them. They're outside of their peer view. However, Shorack and these other guys have to come in and give their testimony, even though they're independent contractors as well. So it's interesting how they're always how the law gets applied always changes depending on which side of the law GFI is on, which is kind of interesting. So privilege determinations. The Olsons have claimed privilege improperly over several documents in their production. First, the Olsons asserted privilege over attachments to communications without providing a description of the attachment. So each document that goes into the attorney eye only is supposed to be labeled why. Why does this need to be attorney's eyes only? And they basically didn't do that. They turned over these 1,000 documents and just said, hey, they're all attorney's eyes only. And so then they gave up some grounds, said, okay, we'll take some of them out. And the attachments are not automatically privileged merely because they are attached to a privileged document. They're playing this game so well. Second, the Olsons improperly asserted marital privilege over communications between Eric and Sandra without logging this information. So they're just turning everything over as attorney's eyes only with no proof of why it should be attorney's eyes only, and they're basically just getting away with it. WFG maintains that the Olsons waived the marital privilege by putting their collaborative business dealings at issue. Third, the Olsons improperly asserted privilege over communications between Braun Hagley, whoever that is, and Mr. Olson before Braun Hagley took over the defense of Miss Olson. So it sounds like maybe they were communicating with an attorney about how to do these things before they actually got into it, before they actually were terminated. So did they go to an attorney and say, hey, how do we pull this thing off? And the attorney is guiding them on how to do this stuff. I don't know. Should that be part of it as well? The parties first conferred on this issue on May 9th and have exchanged several rounds of writing correspondence. After WFG requested to meet and confer on 4 separate occasions, defendants finally agreed to confer on July 9th, which before this agenda was submitted. Unfortunately, the parties were unable to resolve the matter through the conference. WFG requests the court require the Olsons to produce documents improperly claimed as privileged. So they're not even turning those documents over. So it's not even that they're attorney's eyes only, they're just not handing them over. So anything that was communicated between the two of them, they're basically saying is spousal and they don't have turned over. The Olsons' position is that the Olsons provide the following responses that WFG has raised. The Olsons' depositions on the 10th and 11th, so I guess occurring on the 10th and 11th, so we don't know if those actually happen or not. All expedited should be completed. WFG has failed an objection to this court's order that seeks to relitigate objections on the date range. They're so good at this. So good. We've already litigated that before. No, the things that were litigated were things that just happened to include the date range. That both this court twice and the judge have already rejected. This objection is fully briefed and pending. We talked a lot about that. I won't go through that again. So the court ordered WFG to complete its production of documents on May 21st. WFG made supplemental document productions on June 17th, 28th, and July 5th. Several of the people who work for WFG whose depositions were taken also failed to produce documents. Defendants serve the right to raise these issues in the context of the defendant's anticipated motion for preliminary injunction. WFG seeks to raise the complaints about the defendant's privilege log, including challenging longstanding privilege doctrine that WFG acknowledges lack precedent. The parties have exchanged letters concerning these issues with the respective privilege log and conferred on Tuesday morning regarding these issues. So I think this is about the spousal privilege. WFG informed defendants that it intends to unilaterally file a brief letter today challenging the marital communications privilege without adhering to the joint letter brief procedures required by this court, which is the one that we just read. The Olsons disagree with their attempt to modify well-recognized privilege doctrines, but believe that any issue related to the privilege log should be resolved at the same time. Rather than through multiple disputes, WFG files its letter. The Olsons request the opportunity to respond. Defendants have moved to retain the confidentiality of 29 documents identified as highly confidential due to the risk of WFG's retaliation to individuals affiliated with the Olsons. So apparently in these 249 documents, they have to do with people from WFG, who I'm assuming are still working there because you can't retaliate. Well, I guess you could. I guess you could bring a lawsuit against them if they were part of the co-conspirators. So maybe that's not entirely accurate. Maybe they are former, but maybe they're not former. Maybe they're still working with the Olsons and GFI. This court has already found similar documents posed a substantial risk of serious harm that could not be avoided by less restrictive means, and WFG identifies no basis of threat for treating the 429 documents differently From the two, the court has previously upheld the Olson's confidentiality designation. This matter is now fully briefed and set to be heard on July 10th. So we'll probably get some information about that soon. But apparently, this is showing that there's conspiring going on, because there's communications between people who are or were part of WFG. And so I think our speculation of, were they recruiting people from WFG, obviously that seems to be the case. So that keeps getting, I know we already know that that's happening, but it's interesting to see that in follow-up documents that speculations seem to be pretty accurate. And so they're trying to protect those documents so that those people either can keep doing what it is that they're doing, or that they won't get in trouble for what they've previously done. So we'll see what actually happens with that. So that we're basically up to date with everything that's going on now, other than the documents that came in yesterday, and I'll go through those for next week. But kind of interesting. It's sad that we keep having to talk about the same things over and over again, but it's interesting to see what happens behind the scene. At least I find it kind of interesting. So hope that was helpful for you. Hope you guys have a fantastic week. We're so thankful to have power. It's you don't realize how special things are sometimes until you don't have them for a few days, and it got hot out here too. So we're happy to have power and internet. It's great to be able to do this with you guys. I appreciate you. Hope you have a fantastic week, and I will catch you all later. Have a great one. Bye.